Welcome to County Portal, your simple source for local government services and public records. Let's get started.
How far back do apartment criminal background checks go? It's a question that causes a lot of stress for renters, and the answer isn't as simple as you might think. There's no single, nationwide rule, but we can break down what you need to know. First, let's talk about the main federal law that governs this, the Fair Credit Reporting Act, or FCRA. A common misconception is that there's a strict 7-year rule for everything. That's not quite right. The FCRA generally states that arrests that did not lead to a conviction cannot be reported on a background check after 7 years. However, and this is the most important part, criminal convictions can be reported indefinitely under federal law. That's right, a felony conviction from 15 or 20 years ago can still show up. But here's where it gets complicated. State and local laws are the real deciders. Many states have passed their own laws that are much stricter than the FCRA to give applicants a fairer chance. For example, states like California, New York, and a handful of others have their own 7-year look-back period that applies to convictions as well. This means a landlord in those states generally can't consider a conviction that's more than 7 years old. Some cities go even further with fair chance housing ordinances, which might limit what a landlord can look at or even ban them from asking about criminal history until after they've pre-approved you based on financial criteria. So, the number one thing you must do is research the specific landlord-tenant laws for your state and your city. Now, what are landlords actually looking for? They aren't trying to deny everyone with any kind of record. Their main concern is risk. They are looking for offenses that suggest you might be a danger to other tenants or the property itself. This means they focus heavily on violent felonies, sex offenses, drug manufacturing or distribution charges, and a history of significant property damage like arson. A single DUI from a decade ago is far less likely to get you denied than a recent assault charge. The type of crime and how long ago it happened are huge factors. If you know you have something on your record, the best strategy is to be prepared. Be honest and upfront on your application. Sometimes, providing context, showing proof of rehabilitation, and having strong references from a current employer or previous landlord can make a huge difference. You might also have better luck with smaller, independent landlords who can make a judgment call, rather than large property management companies that often have rigid, non-negotiable corporate policies. So to sum it up, there is no one answer. It depends heavily on your state, the type of crime, and the landlord's policies. Thanks so much for watching. If this video helped clear things up for you, please hit that like button,